Well, obviously, we're disappointed that the Supreme Court has struck down Section 4. It's an act of incredible judicial activism, as we've heard. It's also a slap in the face to Congress and the hard work that it undertook in 2006. The Voting Rights Act is one of the few pieces of legislation that has enjoyed bipartisan support in 1965, 1970, 1975, 1982, and even more so in 2006. And so it's very disappointing that the Supreme Court would think that it is the best decider of when racial discrimination in voting has ended in our country. It isn't. The Constitution says that those decisions should be made by Congress with appropriate legislation. The Supreme Court turned its back on the numerous precedents today, as Justice Ginsburg pointed out in her dissent, and also noting, of course, that this was a facial challenge. And in any other area of the law, the Supreme Court would never have done what it did today to turn its back on the rights of racial and language minorities in our country. I join with my brothers and sisters to say that we will go to Congress and we will fight, because we have been in this fight a long time.
Oh, yes.
And we're not turning back now. There's nothing stronger than a made-up mind, said Dr. King. And we believe that this Congress knows, just as it did in 2006, that it can act in a bipartisan way, and it will do so. I am confident, because I know that one day, we shall overcome. Armin Durfner, attorney from South Carolina.